My Lords and my Ladies, continuing on from our submissions before the luncheon adjournment, if I may ask the Court now to look at another authority on the issue of Section 20, and that is the decision of the Court of Appeal in the case of Re W. And this is in Volume 2 of the Authorities Bundle MS 670, tab 30. And in this decision, the President, the Family Division, sitting with Lady Justice Black and Lord Justice Tomlinson, was looking at circumstances in which children were received into local authority accommodation, and there were two questions. One was whether the mother's consent had been properly obtained at the outset, and the second was the degree of control that the local authority was exercising over the placement under the agreement. And this returns to the point that my Lord Carnworth raised earlier about whether or not this was a standard agreement. And in this judgment, particularly, we see Lord Justice Tomlinson, at 680, looking at the terms of the agreement. So if I could just take my Lords and my Ladies through that very briefly. First of all, there is perhaps just to go back to MS 679, there is a critique of the agreement, the substance and the form of it, at paragraph 35 of the President's judgment. And a number of criticisms were made of that agreement in terms of its content, in terms of it being vague, but also you'll see at paragraph 35, the President making the point that the children were not returned to the mother in that case after she had asked for them to be returned. In other words, if you like, withdrawn her consent or her agreement. And he goes on to make the observations. She was entitled to remove the children under Section 28. And he goes on to make a number of criticisms of the way the local authority dealt with that. But of relevance particularly, we would say, is the observations made of Lord Justice Tomlinson, which begin at MS page 680, and set out that the form of the agreement, which is similar to the agreement in this case, he noted at paragraph 41, suggested that there had been a degree of duress, that the agreement didn't appear to have due regard to the fact that the mother's objection acted as a veto. Those are my words and not his. And he goes on to say that it was his view that Section 20 was not enacted in order to permit a local authority to assume control over the lives of the mother and her children in this way. And that chimes to some extent, we say, with the factual circumstances in this case, but also the criticisms that are made about an agreement which is not clear on its face as to consequences and effect. May I then ask the Court to look at the decision of the President, again in the case of Rien, and that is MS 577, Authorities Volume 2. And these observations made by the President are in the context of a decision about adoption and the Brussels II regulation. But we say they are relevant to the points being discussed before the adjournment about the effect of Section 28 particularly. So the President's comments begin at MS 578, paragraph 157, and he makes a number of general comments beginning at paragraph 157 about the appropriate or inappropriate use of Section 20 as a short-term measure as a prelude to care proceedings. He draws he also makes the observation, which is one made by the Quorum Children's Legal Centre, that the effect of a child being in Section 20 accommodation, rather than within care proceedings, has a number of detrimental consequences in relation to procedural fairness, and one that he sets out drawing on the Northamptonshire decision of Mr. Justice Keane, is that it deprives a child of the benefit of a guardian to advocate for the child in terms of decision making. And of course that builds on the point made by the Quorum Children's Legal Centre about the participation of children, the voice of children within the context of the proceedings. But there are 4 problems that the President identifies as running through the overuse or misuse of Section 20. At paragraph 163, and that's MS 579, he says that the first problem is the failure of the local authority to obtain informed consent. And he locates that within Section 27. So he locates the consent obligation within the framework of the entitlement of the parent to object. The second problem he identifies at paragraph 166, and that's MS 581, and that goes to the form in which the consent is recorded. Now, to some extent, that matter, the form in which consent should be recorded is something which the President has previously dealt with in the Nottingham case. It was expanded in the Coventry case. And to some extent, that remains in place following the decision of the Court of Appeal in this case, because Lord Justice Levison's decision was that that is good practice. So the form point that the President makes, that a prudent local authority would surely wish to ensure that parental consent is obtained properly, but he does acknowledge that there's no requirement for it to be in writing. And that, we would say, is consistent with evidencing the agreement, evidencing the voluntary nature. The third problem is his observation that Section 20 agreements are allowed to continue for far too long. I acknowledge that observation is being made in the context of this particular case, the Rien case, which involved a very young child, a baby, and the President was addressing the lack of planning as to the future of that child. So it's a different point to any criticism that is made about the length of the accommodation in this case. And then the last point, which we say has some force and some relevance to this case and to the wider issue of agreement, voluntary nature, is that he's observing the seeming reluctance of local authorities to return the child to the parents immediately upon the withdrawal of parental consent. And he sets out the text of Section 28 and makes the observation that that means what it says. And goes on to say that where a local authority continues to accommodate a child in those circumstances, as happened here, that local authority is acting unlawfully.
Can I just go back to 163?
Of course.
Where, as you pointed out, he seems to equate the need for consent with Section 20, subsection 7, the lack of objection. Was that simply on the facts of this case where the mother did object? Or, I mean, the issue is not strictly has there been consent, but has there been objection? And so yes. When one's questioning whether it needs to be in writing, clearly the objection, I would have thought, doesn't need to be in writing. The parent, if a parent makes clear that she objects, then that's good enough, isn't it? I mean,
yes.
I'm slightly surprised he sort of jumps so readily from the question of the lack of objection, which is what this section requires, to this question of a written consent, which seems to be a different issue.
My Lord, I think that to understand why that point is being made by the President in that way in that case, it arises from cases in which it has been difficult to evidence the agreement.
No, I can understand that.
And we accept that if the term consent is what has emerged in common parlance to describe the evidence of the lack of objection or to describe the agreement that the parents are entering into, that is something which is not written into the Act itself. I mean, we accept that, we have to accept that. Some confusion perhaps arises from interchangeably using consent with lack of objection, but our understanding of the point which is being made by the President here, and if it's not the point that's being made by the President, it's a point that we would make, is that it's the effect of the objection.
No, but in our case, the question is, were they taken away against an objection from the parents? And where the parents have signed a document which says we consent, it's quite a difficult case to make out, isn't it?
Well, they weren't taken away against the objection of the parents because, of course, they were taken away under police protection. And no issue has ever been raised by Mr. and Mrs. Williams about the police protection measures. So it's a slightly difficult point as to removal because they were retained. The accommodation began under police protection and it continued in the face of an objection.
Well, there was then the formal objection from the solicitors, and the question is whether they should have been sent back earlier or
Yes.
whether the bail conditions were a valid reason for retaining them.
Yes.
But it seems to be concerned with a quite different issue to the one which the President was concerned with in this case.
Well, I think...
It's very similar facts, apart from no bail condition, wasn't there?
Well,
Perhaps my Lord will be helped by having an indication of the facts of the case, in case
Yes,
of the because that was similarly a case where children were removed under police protection, accommodated under Section 20, and the accommodation under Section 20 went on for 8 months before the local authority decided what it wanted to do. Now, what I haven't remembered is obviously that case came to this court.
Came to this court on the
We didn't make any observations about Section 20, as I recall.
No.
Although we did have an intervention from the family rights group that wanted us to, but it didn't arise because
It was a Brussels 2
it went off on something else.
Adoption of Children Act.
But what I can't remember on the facts is what was the evidence as to the parents wanting the children back.
My lady, my recollection is that there were a number of occasions on which the parents had indicated, forgive me while I just locate those, that they sought the return of the children.
Well, never mind.
Yeah, don't worry. I'm just trying to understand the context in which the President said what he did.
It's very different, isn't it? In our case, correct me if I'm wrong, I think you said on the 15th of July, the local authority agreed that the plan should be for a return of the children to the parents.
16th. Yes.
16th, thank you. And so we have 7 weeks in which the bail condition has to be lifted. The Child Protection Conference has to decide what safeguards should be in place to support the family at home, and arrangements have to be made to collect 8 children and restore them. Only 7 weeks. It's very, very different in terms of facts, isn't it, Ms. Wantram?
It is, and also the particular difficulty in this case, in the Rien case, was that it involved a newborn child. It was an infant. And the retention or the keeping of that child in local authority care for such a long period of time without properly planning for that child's future and at the same time properly assessing the capacity of the parents with the question of return was what caused the President to make the observations that he did.
Thank you. Yes.
To deal with the issue about the evidencing of consent in this particular case, and I don't wish to repeat points that we have made earlier, but the relevance of a number of cases in which the President particularly, but also Mr. Justice Headley, again in I accept factually very different circumstances, have made observations about the importance of recording consent is illustrated quite well on the facts of this case. Because clearly when one looks at the evidence before Sir Robert Francis and one looks at the findings that he made about the state of confusion of the parents at the time that they were in their discussions with the local authority on the 6th of July, that illustrates in our submission that if consent is not the term that is used, if the agreement is not sought and obtained in that way, then one has this very confusing factual question about the nature of the objection, whether the objection was made, whether it was made in the context of an invitation from the local authority, and whether the parents properly understood, and indeed the local authority, the social worker, properly understood the consequences of any objection that was made.
Sorry, maybe I don't understand the facts. On the 5th of July, they're taken away under police protection.
Yes.
And there's no objection to that from the parents. They then see solicitors, and on the 13th of July, a week later, it's made clear they want them back. So as far as that period is concerned, there isn't a problem about consent, and at least there's certainly no problem about lack of objection. And then from the 13th of July, the question is, well, to what extent were the authority entitled to keep them while these bail conditions were in place? So it's a completely different factual situation, isn't it, the ones all these other cases are looking at?
It's a different factual situation, but there are two factual points that I would just add to my Lord's summary. First of all, on the day on which they signed the agreement, Sir Robert Francis found that they were in a confused state. So there's a question about, did they understand?
Yeah, but why does that arise if they accepted that the children had to be taken away under police protection?
Because the police protection came to an end on the 7th of July, and in the absence of a continuing agreement with the local authority, the children would have to have been returned home. So the local authority...
So we're simply talking about those 6 days between 7th of July and the 13th of July.
Yes, and perhaps we're talking about a shorter period of time, which is the second factual point I just wanted to remind my Lord of from our submissions this morning, and that is that on the 9th of July, the parents went to the local authority and asked for the children to be returned. Now, that was the point that my Lord had raised.
So that would be the first objection, effectively. I mean, that, you would say, would certainly be an
That's
objection.
the first after-the-fact objection.
Yeah. Okay.
But there's the question of the validity of their consent if one approaches it from the perspective or the standpoint that the President has...
Well, then just talking about 2 days or maximum 3 days. I mean, is that what this case is all about?
No, because they weren't returned.
Well, no, but that's a quite different
2 months,
issue.
isn't
The
it?
question whether they should have been returned after the solicitor's letter of the 13th of July seems to be a quite different issue. But if we're arguing about the validity of the form they signed, that is simply concerned with a couple of days, which to my mind is hardly why we're all here.
No, I mean, it's not the only reason we're here, if I may put it that way.
I mean, I can see there are broader points which people want guidance on, and that's no doubt why we're here.
Could I move on then from the Rien case, just very briefly to mention 2 other authorities which were referred to in the court below and which expand on this point that my Lord has been raising, my Lord Conworth has been raising about the relevance of consent and the circumstances in which it is taken. One is the decision of Mr. Justice Munby, as he then was, in the case of G and Nottingham. And that is in Bundle Volume 1. Tab 12. And if I could ask you to look at MS 244. Now, before looking at this decision, there are 2 points I should make in relation to the facts. This case is very fact-specific, as any case is, but it is dealing with the removal of a child in a hospital ward immediately following birth. And so issues arose about capacity, issues arose about the mother's understanding of the consequences, and it wasn't the focus of my Lord's judgment in the case, but he does make a number of robust comments about the use of Section 20 in the circumstances of the case. In particular, at page 244, paragraph 53, dealing with
Was
the question...
this important guidance given before or after the events in the present case?
It was given in 2008, so it followed.
Very well.
Yes. This case was the 5th of March 2008, so it was after. So at paragraph 53, Mr. Justice Munby, as he then was, sets out a number of observations about the consent and the question of whether consent needs to be in writing, makes the observation that it doesn't need to be in writing. And he goes on to say that there may be cases where a child has in fact and without parental objection been accommodated by a local authority for such a period as might entitle a court to infer that the parent had in fact consented. And paragraph 54, in the circumstances of that particular case, he said that the local authority were conflating absence of objection with actual consent, which he criticises and then goes on to say at paragraph 55, to equate helpless acquiescence with consent when a parent is confronted with circumstances such as this is the misuse of a non-existent authority by an agent of the state. Now, those observations and those comments by Mr. Justice Munby in that decision were then the foundation for a decision of Mr. Justice Headley in the Coventry case. And again, a very fact-specific set of circumstances. And the Coventry case is in Volume 1, Authorities Volume 1, Tab 1, MS 9. And the guidance on the use of Section 20 is at MS 14, paragraph 25. And this guidance by Mr. Justice Headley featured in the decision in this case before Sir Robert Francis and also in the Court of Appeal. You can see that Mr. Justice Headley sets out of paragraph 25 that Section 20 contains no compulsive powers, or in fact Part 3 of the Act, with the exception of Section 25, contains no compulsive powers. He makes the observation, paragraph 27, that the use of Section 20 is not unrestricted. That is the point that we looked at earlier this morning. The limitations, it must not be compulsion in disguise. This is paragraph 27. For such an agreement, a Section 20 agreement to be lawful, the parent must have the requisite capacity. The mother in this case had cognitive impairment. And then paragraph 28, even where there is capacity, it is essential that any consent is obtained, any consent so obtained is properly informed. And he locates that within Article 6 and 8 of the Convention.
If the parent doesn't have capacity, can the local authority nevertheless accommodate the child under Section 20?
My lady, the duty would arise under section 21C, perhaps because a parent is prevented. But as with any assessment of ability to parent, capacity isn't going to necessarily be determinative of that.
That's not the question I'm asking. What I'm asking is it lawful for a local authority to accommodate a child under section 20 when the parent lacks the mental capacity to consent to that arrangement? It would be a fairly staggering thing to say no every time a local authority looked after the child of a parent who lacked capacity. They had to bring care proceedings.
My lady, what I think is problematic is the absence of capacity would affect the ability.
Yes, but it's relevant to you're arguing that there always has to be consent, although it's not a statutory requirement. And I'm saying, if you're right about that, does that mean that where there isn't the capacity to give that consent, it's unlawful for the local authority to accommodate the child under section 20?
Well, my lady, that might be a section 24 scenario.
I thought you thought that section 20, subsection 4, was also subject to the implication from the later provisions in the section that consent was required.
I suppose the reason I'm hesitating, my lady, is that the lack of capacity undermines the ability to object. So in the same way that the lack of capacity may affect the ability to consent, it would affect the ability to object.
But it doesn't affect the ability to remove the child.
I'm pausing because I want to.
Well, if you'd like to think about it a bit more, because it's a fairly fundamental question.
Yes, I accept. It is, yes. I mean, may I come back to that point? I'm hesitating because I see difficulties in terms of the reported circumstances in which that has arisen. In the Coventry case, there being a question of the mother's capacity because of the medical circumstances in which she found herself. And there clearly is a difficulty evidencing agreement and evidencing objection where capacity is an issue. But if I can pause there or park that and perhaps come back to it, like if I may to think about it. Returning to the Coventry case, the circumstances in the Coventry case led to Mr. Justice Headley setting out at MS page 18, paragraph 46, a series of...
I do have to tell you that you have a minute left.
Yes, I see that, and as it happens, I'm almost finished. So paragraph 46 set out a series of guidelines, and those are procedural guidelines. They are not disrupted or displaced by the decision in the court below, because Mr. Justice Levison observed that those are good practice guidelines and that they should be followed. But they, of course, apply very specifically to the facts in that case. In terms of the only other matter that I wanted to just flag up for the court, those are the authorities that we wanted to take the court to. In terms of the secondary part of our case, you will see in our written case that we assert that the court below didn't deal with the proportionality question in relation to Article 8.2. So, in other words, if the accommodation of the children was in accordance with the law in relation to the first part of Article 8.2, that didn't negate the necessity of dealing with the question of proportionality in relation to the removal. And there are two very brief points I would make about that. First of all, we have set out in our written case what we say was the correct approach. And secondly, that we would align ourselves with the submissions on the law in relation to that, which are made very helpfully by the Equality and Human Rights Commission. Beyond that, at this stage, we didn't intend to address the court any further on that point, but we say that that's an error from the court below. May I just, before finishing, my lady had raised the issue of whether or not we were inviting the court to look at the parliamentary debates around the bill. And we would like, if we may, to consider that overnight, and it may be something which arises in response to the case from the respondents, if there is a ambiguity put in issue, if you like, by the respondents in their submissions. But we would also like to consider that, if we may, overnight.
Well, you've got a reasonably generous amount of time for reply, so
yes, we do.
Leftovers can be dealt with there.
Yes.
See the bill there.
Oh, definitely see the bill. Yeah.
We've got copies of the bill now?
We do have copies of the bill, yes.
Well, those can be handed round while rearrangements are taking place.
Yes, thank you. My lady, those are our submissions.
If I mean, for my benefit, I'd like to be, if you're considering what you're allowed to refer to, I'd like to see chapter and verse for referring to the earlier versions of the bill.
Yes. So, my lords, my ladies, what we are about to hand up is the original version of the bill, the proposed amendments and the amended version. So Ms McGlynn will distribute that. Thank you.
Well, Miss McGlynn, do you wish to follow your leader? Well, hand over the... Start from the usher will hand it round. Mr. Stewart?
Please, your ladyship, your lordships. We've got 3 hours as well. I'm taking it that probably what we should have is then first thing tomorrow morning. Is my lady going to deal with this point first thing tomorrow morning or in reply? Because it would be quite helpful to us to know before we complete our submissions what my learned friend is saying.
Well, no doubt she'll let you know.
That's fine. If
she lets you know, then you can sort things out.
I've raised the question.
We don't want to be...
No, that's fine. It's we're very happy with that. Lady, we've got 3 hours. Mr. Sinai is going to use the last 20 minutes of those 3 hours, and he's going to deal with specifically with the limitation aspect of the case. And of course, I'm not debarring him from adding anything else brilliant that he thinks of in those 20 minutes. But so I'm going to use 2 hours 40 minutes, and then Mr. Sinai is going to follow.
I was going to ask whether the limitation issue was before us.
I beg your pardon?
The limitation issue, it is before us, isn't it?
It is indeed, yes.
It's not one of the agreed issues.
No, this is not an issue that is agreed.
Well, it's not agreed. I beg pardon. We raise it, my lady, because we have flagged it up specifically in our written case as an additional point, which, in accordance with the rules, as an additional point that we would take in support of the decision in our favour in the court below. Yes,
well, you don't need permission to. You don't have to cross appeal if you're going to support the decision of the court below on different grounds. But on the other hand, if you're really seriously trying to get us to look at the exercise of discretion by a trial judge, that's
Well,
you have an uphill struggle.
there's a challenge for my learned junior, my lady.
Well, that doesn't mean to say that we're necessarily going to be very sympathetic to it.
The decision below was to dismiss the Article 8 claim.
Indeed.
Would a decision that the Article 8 claim be barred be the same as the decision made in the court below?
Good question.
They have the same result, my lord. Exactly the same result. It would mean that the claim fails. So
I think it's conceptually a different disposal.
well, it's conceptually a different basis for the disposal, my lord, but the effect is exactly the same. That the appeal is dismissed, and the decision of the Court of Appeal, which is to set aside the judge's order for 20,000 damages and breach of Human Rights Act, is the Court of Appeal's decision on that stands. The trial judge's decision remains set aside by the Court of Appeal, and that's the end of this appeal. That's our position on that. But my lady and my ladies, my lords, we heard what you've said on the limitation point. Mr. Sinai has heard what you said on the limitation point, and we'll think about that. By way of introductory comments, then, we've got some clear findings of fact by the trial judge, which are the basis of our approach to Section 20. They're not all the findings, but there's a useful summary at 3023, MS 3023. This can be found in other places, my lady, but at 3023, we've got the judge's relevant findings. This is conveniently taken from the appellant's skeleton argument in the court below, but it's quite handy to have it there, Lord. In paragraph 12, contrary to Mr. Williams's denials, he did hit his children at times with a belt, and then the appellant, that's us, was justified in considering the allegations are evidence of a risk to the safety of the children, that the police bail conditions which prevented any unsupervised access between the children and their parents were at least a practical impediment to the return of the children to their parents. It's a little bit puzzling as to exactly what at least a practical impediment is. We will say it's rather more than a practical impediment, but certainly impediment is the key word. And also throughout the period of care, no realistic alternatives such as extended family members of the members or friends were provided by Mr. and Mrs. Williams to the care of any of the children. That's relevant to subsection 7 when we look at it. And that the respondents did have capacity to understand. Of course, the judge's findings about whether they'd been sufficiently informed and whether they sufficiently understood. But on the basic issue of capacity, he made that express finding. And he also then found that the use of Section 20 was proportionate given the circumstances of this case. And then he refers to, then in point 6 there, the overall thinking the children needed to be kept in foster care while investigations were completed and the bail position was resolved. And the contrary is not consistent with the actions taken thereafter, or indeed with an appreciation of the practical reality. So we very much respect, despite the fact the learned judge found against us, we do endorse and we do note those findings, which are important.
Before you move from the findings, can I just try to find out what the judge found on the question of the parents' attitude on the day that they signed the agreement, which was the 6th of July, wasn't it?
Yes.
It looks as if, from paragraph 39 of his judgment, that the social worker agreed that the notes showed that Mrs. Williams did not want the children to be accommodated.
Yes.
And then the judge doesn't make any contrary finding to that. Is that right?
That's correct. If we leave aside the written agreement, but as a finding of Mrs. Williams's attitude, and also
Which paragraph was that?
39.
Oh, no, thank you.
And we also recognise that the judge indicated that, of course, the parents were in an emotional and confused state. We recognise that.
But I'm just trying to work out when, if at all, they could be said to have indicated that they did not want the children being accommodated. That was one reference to it.
Yes.
Then there were the letters from the father's solicitors, which were two in sequence on the 12th or 13th of July.
Yes.
The first of which was slightly equivocal, but the second of which was clear
Yes.
that they didn't want the children to remain accommodated. Was that the one that said beyond 10 days?
Yes, that's right.
Right.
Yes, exactly.
Did the judge make any finding about that?
Yes, he regarded that as a clear indication. So
So the reference to that is, please.
Mr. Sinai will find that reference, my lady.
Thank you very much.
And then that we're going to observe then that that we'll come back to some of those aspects anyway. Maybe simply note that these events happened in 2007, so later statutory guidance, though you haven't been taken to it specifically, but it is referred to in the written cases. Later statutory guidance is strictly irrelevant on this appeal because these events occurred in 2007. By contrast, of course, the Coventry guidance, which is also post-2007, that either states the law correctly or it doesn't. And so far as it states the law correctly, then of course it applies, even though these events occurred before that. That's elementary. We say it doesn't, and of course, well, that's what the Court of Appeal said, and naturally we seek to uphold that. The Court of Appeal's view was that the Coventry guidance, though helpful and useful guidance, which should continue to be followed, and I do want to make clear on behalf of Hackney that Hackney are not suggesting that the guidance given by Mr. Justice Headley and the President are not valuable guidance, which they would seek to follow, subject to any amendments of it. But the really critical thing for this appeal is, does it represent the law? And particularly on the question of consent. We'd also say as an introductory comment, and it's our final introductory comment, that labelling Part 3 of the Children Act as voluntary and Part 4 as compulsory is too crude. And it begs the question, and when we go to actually analyse particularly Section 20, we will see that it isn't as simple as that. It's not just that everything under Part 3 is voluntary in the sense that it's got to be with the agreement or consent of the parents, and then everything, of course, in Part 4, that's true, of course, everything in Part 4 does require going to court. A better broad distinction before we actually home in on Section 20 is to say that the distinction is between no court intervention in Part 3 and court intervention under Part 4. And so
you're not going to suggest that local authorities are entitled to impose services on families against their will under Part 3, are you?
Well, I'm going to impose service. I'm going to direct your ladyship's. I said direct. Sorry, that's a slightly cheeky way of putting it, my lady. I didn't mean that. We're going to go to. I'm going to point to Section 20, and to some extent, I am going to make that suggestion. Yes, my lady, do make that, or we do make that suggestion in a way that we will explain.
Well, it's one thing to say that they can do things without consent.
Yes.
It's another thing to say they can impose things against parents' will.
Well, my lady, may
No
I,
problem with the first of those propositions. It's the second one.
well, may I invite your lady to allow me to go specifically to Section 27, to Section 20, because the answers to your ladyship's questions will come from those submissions. Whether in the end you accept the answers or not, that's the way that we would propose to deal with it. The Hackney provided this accommodation. Our primary submission is that Hackney provided this accommodation under Section 20, subsection 1, which is a duty owed to each child. And we don't really need to go to the case, but in the case of Southwark, which is in it's in Authorities Bundle 1 at tab 14, that's clear from the judgment of your ladyship, Baroness Hale, at paragraph 24. And that's... my lady, of course, there's no dispute these were children in need in the Hackney area. That's absolutely not in dispute. And it's established, and this was referred to by Ms. Fottrell in her submissions, that subsection C in paragraph C in section 20, subsection 1, is to be given a wide interpretation. And that's been made clear, including by your ladyship, Baroness Hale. Now, that it's, of course, paragraph C which plainly applied here, because, and this is where we say the parents were prevented from accommodating the children themselves. And these were the express findings of the judge at paragraphs 27 and 31, and we can see that in the transcripts are in Appendix 2. We go to Appendix 2 doesn't is I beg pardon, it's in Appendix 1.
Yes.
I'm so sorry, that's at page, the judgment starts at page 2918. And if we look at the judge's findings in paragraph 27 in the first place, the records of bail produced to the court are not signed by either claimant, but instead in the space for the signature of the person bailed is typed the word incapable. Consistent with what Mr. Williams told me, he said he and his wife were in a dazed state when they left the police station. So that has a bearing on the comment made by Lady Black a few moments ago. And then the passage that we mentioned earlier, about 5 lines on the bottom, the legal consequences of this condition will be considered below, but as will be seen, it was at least a practical impediment to the return of the children to their parents' care. Although the condition was silent as to the nature of the supervision expected, it was interpreted as requiring the presence of a social worker during any contact with the children. And then at 31, he's expressed his concern, surprising no contemporaneous record of the steps taken to look for alternative accommodation, but his conclusion at the end of 31 was, I conclude that throughout the period with which I am concerned, no realistic alternatives were available. The defendants did probably take sufficient steps on the 5th of July 2007 to satisfy themselves of the position at that time. So that was the learned judges.
But that's, of course, while action was being taken, the police protection action was being taken.
At that point,
not Section 20
at that stage, that's certainly correct. But but what the judge was referring to at paragraph 27, that's true initially, my lady. But the judge has referred specifically to the condition on the bail form to prevent not to contact the children unless supervised. And of course, that continued throughout, which is central to our case.
Could I just ask a question?
Of course.
Is there a sort of standard form that the police fill in when they're using their powers under Section 46?
I don't know the answer to that, my lady. The form used it certainly looks like a standard form, but whether for that particular police force or
I mean, the authority
wide...
for these children to be looked after was the authority of the police decision under Section 46.
Yes,
and I would be surprised if there weren't some bureaucratic requirement. I mean, bureaucratic in the good sense, of a proper record of when the decision was taken, by whom, and on what basis. Because clearly the reason for imposing the bail condition, which you've helpfully drawn our attention to in paragraph 27, doesn't bear any relation to the proper grounds for invoking the powers under Section 46.
Well,
Prevent interference with victims actually means stopping alleged perpetrators from contaminating the victim's evidence. That's a perfectly proper police consideration, but it doesn't feature in section 46.
Well, I think there seem to be two different questions. They impose the police protection order under section 46, but then the bail is a separate issue. The bail
It is a separate issue, and that's why I'm asking,
yes.
What were the grounds for taking the children? What were expressed to be the grounds for invoking police protection?
What happened was that the local authority, I beg pardon, the police invited Hackney to go along, and there were two problems. One was that the police were interviewing the parents specifically in relation to the allegation made by the son whom they'd interviewed that the father had assaulted the children. And secondly, as the judge indeed found, that at that point, although happily it was sorted out quite quickly, but at that point the accommodation itself was in a terrible state, and that's a clear finding. It was in a terrible state in terms of hygiene, in terms of lack of food, and so on, and also and dangerous wires. It was in a, as the judge also found, it was in a terrible, unsuitable state for accommodation of children.
I'm not suggesting that grounds didn't exist.
No,
I'm just looking for
yes, well,
some sort of respectable formality in relation to.
But what's wrong with interference with victims? Isn't that what it's about?
I'm sorry, Bernard.
I thought it was about. Oh, I said, was that bail?
Yes, that's the reason,
I see.
the imposition of the bail condition, and it wouldn't be a good reason to take the children away from their parents necessarily.
Lady, the answer to this specific question is we have never managed to get the police file. So we tried to get.
We don't know whether there's a police file that's got a form on it. Yes.
Well, that's right. So we've never managed to get the police file. So such a document we simply cannot have.
Even though
So Robert reasons it out in paragraph 28, and he says it's agreed that the section 46 order of the police was justified for reasons A, B, and C.
Yes.
But he doesn't answer my lady's question, which is, where is the record of what was in the mind of the police when they exercised these powers?
I mean, I completely understand that at the police's invitation, social workers went along to the home.
Yes.
And social workers had both the report of the allegation and they could see what they could see. So I'm not suggesting that there weren't good reasons, but I do want to know.
No, we can't help on that, lady. We do not have that document. We've not been able to get the police file. We do not have the formal document which records that order.
Would you not think, just possibly, that if a local authority is acting in effect as the police's agent for what is a compulsory process, the local authority ought to insist that they have some proof that the police have in fact invoked this power, and why?
Well, lady, I appear for a local authority. That all I can say is that would seem to be a perfectly sensible and realistic suggestion. I can't really argue with that, can I?
Stuart, I think if this is an important point, we need to go into it. But as I understand it, no one has questioned the exercise.
That's right, Lord. It's not important in the sense that it is accepted. It's been acknowledged many times that there was a police protection order. It did last for 72 hours only, but during that period, there was no choice.
So it's perhaps not surprising that no one has dug around in the police files to find out what. I can see why no one has dug around in the police files to find out what, if any, form there exists. But I agree. I mean, obviously, I agree with my lady that one would hope that it does.
Well,
I can see why it's not been an issue in this case.
Well, Lord, we might have dug around in the police file if we'd ever had it. Yes.
It may be just one of those distractions that I shouldn't be putting to you. But nevertheless, if we're being asked to give any sort of guidance as to good practice in these cases, this has struck me from the word go as being a rather important.
I can't argue with the. But don't need to in the end. Ultimately, I can't argue.
I'm sorry, I mustn't continue to distract you from.
Well, by all means.
But it does seem as if there's a Home Office circular dealing with the use of the powers under Section 46 by the police.
There is one, is there?
There seems to be.
Doesn't surprise.
Or there was at some point, anyway. I found a reference to it.
My Lord, could we go then to the Court of Appeal judgment, please? That begins at 2883. And then just look at the endorsement here. This is a paragraph 67. We can go in the judgment, which is at page 2907. That the reason for the parents being prevented from caring for the children was that it was a term of their bail that they had no unsupervised contact with them. This was a condition lawfully imposed on their bail, which over the weeks following the expiry of police protection, which of course was after the 72 hours, was not the subject of any application to the court for its discharge as it could have been. These were proceedings over which the local authority had no control and were not even parties. It's sufficient to say that in my judgment it would have been wrong for the local authority to conduct itself in a way that was inconsistent with what was known to be a term of the parent's bail. Furthermore, at least at the beginning, and this is, was inherent in the answer I gave a few minutes ago, at least in the beginning, the accommodation was not suitable for the purposes of section 21C because of its state. And then at paragraph 76, the 76 dealing with the bail conditions, thus the continued existence of the bail conditions had the twin consequences that Mr. and Mrs. Williams firstly were prevented for whatever reason, which is the point just made, and secondly were not able to provide accommodation for them in order to trigger their statutory right to object under subsection 7. And this is a nub point, my lady, because in quite a number of the authorities that you have been shown, the parent clearly did have the right to object under subsection 7. So it's a very different case altogether. In this particular case, we say they didn't, and we will attempt, my ladies, to disentangle these different concepts. We can see that sometimes they are quite hard to disentangle in practical terms, but there are the three different concepts. Consent, which is being said to be required under section 20, although not mentioned in the statute. Object, and my Lord Carnworth was mentioned this distinction a few minutes ago. Object, which is there in the statute in subsection 7, and then the right to remove the children under subsection 8. And it is important, we suggest, and we'll try to do that, to just disentangle those concepts and see how they work. And the point being that we say that the first of those, consent, actually isn't there and isn't to be read into the section either. We say, if we're looking at section 20, we say that the requirements were also met for the use of the power in subsection 4, but primarily our case is that Hackney was under a duty throughout the whole of the period, and when I say throughout the whole of the period, I'm talking about the period from July. We can, if you like, we can say from the end of the 72 hours for the police protection order, from July right through to when the children were returned in September. And because a point that arose a few minutes ago, just towards the end of my learned friend's decision, that if the appellants are right that Hackney couldn't lawfully accommodate the children because through at least most of the period they didn't have consent, as my lady Baroness Hale suggested a few minutes ago, entirely correctly, that applies to subsection 4 as well. So that would prevent the exercise. Well, it would take away the duty in subsection 1, but it would also prevent the exercise of the power in subsection 4. And there is that distinction. Subsection 1 is clearly a duty, and subsection 4 is clearly a power. And whether my lady Lady Black dealt with this point in one of the authorities we looked at, whether that has the effect of that there is no duty at all in those circumstances. If there's a valid objection under subsection 7, whether that has the effect that there is no duty, or whether it has the effect that there is a duty which then doesn't fall to be exercised. It's certainly a theoretical, analytical distinction, but in practical terms it doesn't matter, because the effect of subsection 7, where it does apply, is, we say, it nullifies the duty in subsection 1. You cannot do it. It's subsection 7, where a valid objection is made, is absolutely clear. The local authority may not provide accommodation under this section. And so, in those circumstances, if the local authority wants to do more, then it's got to go under Part 4. It then does have to use the various procedures under Part 4. Now, so subsection 7, which is really at the heart of this, of course we've got to deal with subsection 8 as well, and in accordance with what we were saying about disentangling the concepts. We have to explain how that works or doesn't work in particular circumstances. But subsection 7 applies, as we said, to the whole of section 20. It applies to subsections 1 and to subsection 4, and of course it means that, subsection 3 just doesn't arise either. The appellants in this particular case met every requirement of subsection 7, except that they were not able to provide accommodation. And I say except because it's an absolutely critical exception, because what it meant was that they were not within the category of persons who were able to raise a valid objection under subsection 7. And that is clear. Now, we have to base that, of course, on saying that they were willing, of course. There's no question about that. We base that on saying that when we look at subsection 7b, is willing and able, and to provide accommodation, and then the judge's findings take care of little Roman 2 arranged for accommodation, because there was no alternative accommodation suggested. So the question then was, were the parents able to provide accommodation? Now, leave aside those early few days. We are talking about the whole of the period. And it's our case that they, and we'll explain, of course, and deal with the question of their ability, but on the footing, which we come to, that they were not able to provide accommodation for the children, they could not raise a valid objection under subsection 7. Because that's what the subsection says. It's as clear as that, and there is no way out of that wording. That's what it says. So there are, in theory anyway, there are 3 possible ways of deciding if the parents were or were not able. One is suggested is that it's the parents themselves, that the parents themselves say whether they are able. And the suggestion coming from the appellates here is that the parents say that they're able, and that question then has to go off to be determined by the court and can't be determined by the local authority. Now, we actually would be rather dismissive of the suggestion that it's the parents themselves that can decide, or it's the parents themselves that can trigger what we would say is unnecessary steps simply by saying we are able, when actually on any appraisal of the circumstances and the facts, they are not. So number one, which we are dismissive of, but we say rightly dismissive, is the suggestion that the parents themselves decide. The other possibilities, and really they are the only other possibilities, are that the local authority decides it, as long as, of course, it's in good faith and taking account of all the normal criteria for the valid exercise of a statutory duty or powers, with, of course, judicial review if you get it wrong. So that's the second possibility. We'd say the first real possibility, and then that it is a question of fact, so that the local authority either gets it right or wrong. Now, we can go to it if necessary, but we don't feel that it is necessary to do it. It's dealt with in cases of Croydon. Well, perhaps we should go to it, actually. In Authorities Bundle 1, if we go to Croydon in the Court of Appeal first, at tab 7, which starts at MS 100, and my lady, Baroness Hale, will be familiar with this case because she was
Of course, a lot of trouble.
The cases often do, my lady, I know. Because you were in the case in the Supreme Court. But looking first, because it's important to do that, but looking first at the Court of Appeal decision, the key point, we don't need to grind through all the facts here. It was an asylum seeker. And the first line of the head note, the first applicant arrived from Libya seeking asylum, claiming he was 16, almost 17. And then there was another applicant making a similar claim, a little bit younger.
Possibly, Mr. Stewart, we should make it plain. I mean, I am familiar with these cases, but not everybody is. These are cases about whether or not a person is a child.
Lady Mayor, I'm coming straight to that, if I may.
That's right, just yes. To make that plain. Yes. And the decision was that, yes, whether or not a person is a child is a precedent fact, a jurisdictional fact, on which everything else turns, and therefore that is something that the court has to decide.
Well, your ladyship is we're on the same page, may I say, because the next bit I was going to refer to was simply the summary of that. At the very foot of that page, for Section 20 to operate effectively, social workers had to decide the age of the applicant. And then over the page, the nature and process of the decision required the implication of words into Section 20, so that it read, every local authority shall provide accommodation for any person whom the local authority have reasonable grounds for believing to be a child in need. And then Lord Justice Ward was dealing with the matter, and he dealt with the precedent fact issue starting at page 115, and he correctly pointed out, we say that paragraph 22, in the middle of paragraph 22, that the determining factor is the supposed intention of Parliament. And he made the point, paragraph 28, he said that Mr. Bear for Lambert and Mr. Bryan responds telling that if it is it's correct that as the appellants contend that in the case of every dispute the courts have to determine age, then the consequences would be adverse to good administration. That the cost of processing such claims will be considerable, there will be significant delay, urgent decisions that have to be taken in the interim, and all of this uncertainty and delay will be inimical to the welfare of young people, thereby undermining a crucial cornerstone of the Children's Act philosophy. And then then at the bottom of the page, thus Mr. Bear and Mr. Maguire submit Parliament must have intended that all necessary decisions to be made quickly and with a minimum of formality by those operating the service on the ground, and drew support from Lord Griffith's speech. And then his view, he says, over the page at 120, the MS number, middle of the page, by contrast, for Section 20 to operate effectively, it's the social workers who decide the age of the applicant. And then going down to 31, even though I'm satisfied those words must be implied for Section 20 to operate effectively, I acknowledge the draftsman could have made the position clearer. To remind us of it, Section 20, subsection 1 reads, every local authority shall provide accommodation for any child who appears to them to require accommodation. So the section could easily have read, shall provide accommodation for anyone who appears to them to be a child in need and to require accommodation. And he says that despite the failure to spell out the obvious, I'm satisfied the scheme of the Act compels that conclusion. In contrast with parts 2 and 4, which involve decisions being made by the court, part 3 is concerned with administrative functions of the local authority. And then over the page, he cites from Sir Stephen Brown in Hazel and Hammers, approved by the House of Lords, the words functions used in a broad sense apt to embrace all the duties and powers of the local authority. The sum total of the activities Parliament has entrusted to it, those activities are its functions. The only person able to carry out local authority functions is the local authority. Parliament must have intended the local authority to take all the relevant decisions. Now,
of course, you're telling us all of that, but the Supreme Court decided something different.
No, I accept that, my lady. I'm aware of that. That's not, with respect, my point's going to be a slightly different one. I am aware of that. And then...
what is the point? Then we can see what...
The point is that, that this is a decision that age is, and as the Supreme Court held, age is a much more clear-cut...
And you're saying that this, you prefer Lord Justice Ward's reasoning in the context of our case, is that what...
I'm saying that there is a distinction that Lord Justice Ward's approach there is apt for the question we've got here about ability, whereas age is a much more clear-cut fact. And of course, we're not going to argue with the decision that was reached by the Supreme Court in that case, that when you are drawing the line between an issue which is a question of fact which is for the court to determine and a question which is for...
Well, it's a difference in your age is a question of fact, however difficult it is to determine, whereas your ability to do something involves an element of judgment.
Element of judgment.
That's the point you're making.
Wouldn't you do better to go to the Supreme Court where that distinction is actually drawn?
Well, I was going to do that. Perhaps I should have done it more quickly, maybe. But
Lord Justice Ward, whose 80th birthday it is tomorrow.
Well,
yes, today. Tomorrow. Today.
So his age is obviously determined.
Well, we certainly hope so. If we go again then to...
Well, if I'm correct in my recollection, the Supreme Court drew the distinction between the decision as to what the age of the child was, because the whole of the Children Act depends upon the people in respect to whom decisions are taken being children, and the evaluation as to whether a child was a child in need.
Exactly, my lady. But okay, all right. I wanted to indicate what the...
I would have thought that was a point in your favour.
Well, it's if we go to page 150 in tab 8, and this is the Supreme Court judgment. I can take this quickly. The question in paragraph 26. And this is in your ladyship's judgment, you say, the second line, the 1989 Act draws a clear and sensible distinction between different kinds of question. The question whether a child is in need requires a number of different value judgments and so on. And then at the top of the next page, questions like this are sometimes decided by the courts in the course of care or other proceedings under the Act. Courts are quite used to deciding them upon the evidence for the purpose of deciding what order, if any, to make. But where the issue is not what order should the court make, but what service should the local authority provide, it's entirely reasonable to assume Parliament intended such evaluative questions to be determined by the public authority, subject to the control of the courts on the ordinary principles of judicial review. Within the limits of fair process and Wednesbury reasonableness, there are no clear-cut right or wrong answers. But the question whether a person is a child is a different kind of question. There is a right or wrong answer. And, my lady, and then you draw the distinction with the question of a child in need. Of course, there, the words "it appears to the local authority" are in the statute. But what our submission would be that but in the end, we also say it doesn't matter that much, but our submission would be that the evaluation of ability or the question of whether the parents are able to provide accommodation falls much more aptly into the box of evaluative judgments to be made by the local authority than a factual question such as age, which is for the court to determine. but we say that in any case, it doesn't matter in the current appeal, because, but I mean, this is a point that was argued by the appellants here as to who makes the decision. We stick by our suggested dismissal of the parents themselves, but we say that in this particular case, either, which is our primary position, it was for the local authority, and for all the reasons indicated by Lord Justice Ward as to the practicalities of the local authority's work and the local authority's functions here, it was more likely to be Parliament's intention that the local authority should make that judgment as one of those listed judgments referred to by Lord Justice Ward, to which your ladyships and your lordships were taken this morning. But that if that's not so, if it is a question of fact, it's completely wrong to suggest that that means that it's got to go to the court every time. Just because it is a fact, as opposed to a matter of a judgment of the local authority, doesn't mean, and what the Supreme Court also indicated in that decision was that in the first place, it's for the local authority, even if it is a question of a fact, of precedent fact, to be judged by the court, that the local authority is still expected to make an initial judgment on that point. In the same case, at tab 8, at page 152, that's memory stick, I'm slipping it out, memory stick 152, halfway through 33, clearly, as those cases also illustrate, the public authority, whether the Children's Services Authority or the UK Border Agency, has to make its own determination in the first instance, and it's only if this remains disputed that the court may have to intervene. But the better the quality of the initial decision-making, the less likely it is that the court will come to any different decision upon the evidence. Now, clearly, if the local authority gets it wrong, for all the supposed deficiencies in the judicial process, the judicial review process, we'd suggest with respect, it's not that deficient. The fact is you can go on judicial review. If you really have got that wrong as the local authority, then your decision will be set aside.
Can I just explore how this works then? So if the local authorities say that the parent is not able, that defeats the parent's wish to have the children home.
It defeats the right to, may I take it in steps, it defeats the right to object.
Yes,
under subsection 7, yes.
Consequence, children don't go home.
Consequence that the local authority are in the circumstances of this case where the parents are prevented from providing accommodation. The local authority, and it actually, the observation that your ladyship made in the case cited has a bearing on this, means the local authority remains under the subsection 1 duty,
yes,
without the parents having any right to object under subsection 7.
Practical consequence, it defeats the parents' wish to have the children home.
That's one way of putting it.
Right, so just bear with me for a moment.
All right, yes, I will, of course, that's one way of putting it.
And the means of challenging that defeat for the parents is to go by way of judicial review.
If the dispute is, if the parents say, you have got it wrong, we are able, and that is not, and if it's a matter of fact, and that's our secondary position, after all, if it's a matter of judgment for the local authority, then that gives a wider range, if you like.
All right, but the vehicle is judicial review.
Yes, let's take it that it is, let's take it to start with that it is a question of fact. So as Baroness Hale put it in that authority we looked at, they either get it right or wrong, right? You go on judicial review and they're told they got it wrong. And if they're told they got it wrong, then...
So the question of ability is therefore litigating their ability to look after their children, but in the context not of the normal provisions, which is part 4 of the Act, but in the context of part 3. Have I understood correctly?
That's correct, my lady. Yes, because what's happening is that absolutely correct, that the local authority is saying, we have the duty under subsection 1. You do not have the right to object under subsection 7 because you are not able. And the parents are saying, no, we're challenging that. We're going on judicial review.
So the threshold imposed by section 31, and in a slightly different form by section 38 in part 4, for the intervention of the state into the care of children by their parents is absent.
Well, it's absent, my lady, but it's absent in circumstances where the duty arises because the local authority has, we're assuming correctly, the child has been identified as a child in need within the area, etc., who requires accommodation. So that what we've got is we've got a duty to provide accommodation for a child who otherwise has no accommodation.
Just one final question
Yes, of course.
before I let you get back to your submissions. And all that can be trumped by the parents acting under section 20, subsection 8.
I'm going to, if I may, my lady, may I come to section, rather than try to answer that now and get all tangled up, because it is part of our case to keep these concepts separately.
Okay.
May I come?
Sorry, I was just wanting to look at the practicality.
Indeed, it's
Mr. Stewart,
the lady.
I'm not sure that is much of an answer to my lady's point. I've been listening intently for the last quarter of an hour to your analysis of judicial review that the parents wrongly assessed to be unable to provide accommodation can use. But my lady has pointed out, and you've got to look at these sections together. My lady has pointed out that where a parent has wrongly been assessed as being unable to provide accommodation, so her objection is irrelevant, she doesn't use judicial review. She says subsection 8, I'm entitled to remove. So there's an air of unreality about your submissions, in my respectful suggestion.
Well, what I'm trying to do, Lord, is analyse the section, first of all, to see what it says and to see how it works in its own terms. And I'm not going to shy away from grasping with the reality. If I promise that I am going to grasp with reality and I am going to deal with subsection 8, but I do want to get it very clear what the section says and what you can't say and what can't be done, consistent with the clear wording of the section. And so in the first place, you cannot, if we take that after judicial review, it may be that in practice it gets sorted out some other way, but we're analysing where it actually leads in terms of what the section is saying, and assuming, against my primary submission, assuming that this question of ability is a question of fact, so you're either right or wrong. And if it's seriously suggested that the local authorities got it wrong, then one route, or if you like, one legal route then, is to say you've got it wrong, this is an invalid exercise of your statutory powers or exercise of your statutory duty, you've got it wrong, we're going to go to court on judicial review and you are going to be told you've got it wrong.
Mr. Stewart, you probably haven't had the opportunity of looking at the Trojan Bill that was handed up this afternoon.
Not yet, I haven't, my lord. No.
It is absolutely fascinating. You will see that as originally drawn, subsection 7 and 8 of what was then clause 17 of the bill had a perfect symmetry. And then there was this suggestion that for a particular reason we should shove in to subsection 7 this business about willing and able. And it has completely distorted the pure and logical balance between the two subsections. It's fascinating.
Yes, Lord, although I haven't looked at the bill, we haven't looked at the bill, we believe we do have an idea of where that disruption of the seamlessly smooth logical scheme came up. And we do have something to say about that. But it may be that your lordship and others maybe cry that disruption of the seamlessly logical scheme, but we are where we are.
Oh, yes.
As far as subsection 7 is concerned, and so we're agreed on
Very
that.
well, thank you.
Yes, and so looking at what subsection 7 says, in the case where the parent is not able, it wipes out objection under subsection 7. So it removes may not accommodate under this section. So it restores, and I think this is as indicated in that passage from Lady Black's judgment in the other case, if you like, it restores, notionally, if you like, the local authority's duty under subsection 1. So that's where we are, because these children, in these circumstances, with the parents being prevented from providing accommodation, no alternative accommodation, these children have to have accommodation. And so the duty arises. Now, so far as this question of ability is concerned, it's not so much, my lords, that I'm suggesting that it's a sensible, productive way for the world and the care of children to operate, for everybody to be rushing off for judicial review all the time. It's what we do say here is that they obviously weren't able. And so in circumstances where it may be that it's a question of fact, but in accordance with the guidance given in the Supreme Court decision that we looked at a few minutes ago, it's a responsible authority has to form its own initial assessment. It can't say, well, we're going to run off to court. I mean, that's even more ridiculous. You can run off to court every single time you've got a factual question, which is a precondition for your duty. As indicated there, of course, the local authority responsibly says to itself, what is the answer to that factual question? And in this particular case, it's answered the factual question correctly by saying they weren't able. And initially, of course, the judge found that they weren't at the initial stage. The Court of Appeal, we say correctly, is saying that throughout the whole period, they were not able to provide accommodation because that would have been a breach of the bail condition which applied throughout. And so there wasn't, if we talk about it in terms of judicial review, judicial review wouldn't get off the ground here. The idea that somebody could have challenged the local authority's assessment in this case that the parents were not able to provide accommodation, it wouldn't have got past stage 1. So it's not that it produces some unworkable scheme. What does produce an unworkable scheme is the suggestion, if we understood it correctly from the appellants, that whenever the parents say, we dispute that, so that there is a dispute between the parents and the local authority about the parent's ability, that you have to get the court to determine it. Because in the circumstances such as we have here, the local authority said, well, dispute away, but it's clear. I mean, we put it tactfully, of course. As a matter of fact, in all this, whatever criticism made of Hackney, the discussions with the parents and the assistant to the parents to get the flat very quickly into a very good state, actually credit is due to everybody here, to Mr. and Mrs. Williams and to Hackney, because they got it sorted out very quickly. But certainly a responsible local authority would have to say, I'm sorry, you're telling us that you're able. We understand you say you're willing, but I'm afraid you're not able, and that's that. And if the parents then said, oh, we want you to get the court to decide that, and they started referring to authorities and said, well, it's a precedent fact and so on, the responsible local authorities said, I'm sorry, we're not going to waste public resources going to court to be told that we're obviously right.
Well, another possible way of handling that would be for the parent then to say, right, well, I want my children back. You say that I'm not able and willing. I want you to stop accommodating my children. Subsection 8.
Yes.
To which the local authority says to itself, well, that's not realistic, but it means that we're going to have to invoke care proceedings. Maybe with a emergency protection order first, if removal looks imminent. And then, of course, everything that requires to be investigated in care proceedings can be properly investigated. Isn't that an alternative scenario?
Well, Lady, we're taking the stages. If we take the position that, and we'd agree, by the way, with, and it's a point without going to it, that the appellant's written case at paragraph 67, and the memory stick reference there is 2767, they make the assertion that section 20 subsection 8 presumes that the child, I beg your pardon, presumes that the child is already in the care of the local authority. Well, that must be right, because it's removal of a child. So that's clearly right. And part of our attempt to keep separate and to disentangle and analyse these provisions are that section 20 subsection 7 kicks in before the local authority take the children into accommodation. We accept entirely that though it kicks in at that point, it remains, so that as Baroness Hale indicated, it's a continuing process, the provision of accommodation, so that we would accept that a valid objection under subsection 7 can be made later, and the local authority then may not provide accommodation. But subsection 8 is presuming that the child is already in the care of the local authority, so it by definition, it kicks in later. Section 20 subsection 7 will come up first before there's any question of a right under subsection 8. And I recognise, and we propose to deal with what's been forcefully put to us as the practical implications, because if you clearly we can see that if you are providing accommodation and you're saying there's no right to object under subsection 7, in the real world, you think to yourself, well, actually, there is subsection 8 lurking there, and if it's obvious that subsection 8 is going to present a standoff, then you might preempt that standoff by saying, well, look, in these circumstances, we really need to go to court under Part 4. See that. In practice, we understand that the most, there are a number of different ways of doing it, but the one practical situation in which, and way in which subsection 8 is actually used is, for example, where the parents will simply go and meet the child after school. It's the easiest way of doing it, in effect, rather than going to wherever the accommodation is, or where obviously local authority officers are hardly likely to be in attendance, or to go to the local authority offices where the children are not there. So in practice, the parents are likely to meet the child after school, take them home. And
Mr.
then...
Stewart, you'll have to consider very carefully my lady's hypothesis to you 3 minutes ago of, well, what about taking care proceedings? But we'll have to consider that, won't we, in the light of the fact that as early as the 16th of July, your authority evolved a plan to return the children home. And for the next few weeks, the local authority and responsible solicitors for the parents were engaging with the local authority in order to achieve that. And so we'll have, won't we, to consider whether there was a legal necessity for care proceedings in circumstances where everybody was moving towards what was hoped to be, and what was by and large achieved to be, a reasonably quick return.
Well, there's the question, well, there are two separate questions. One is whether it would have been a perfectly reasonable course for the local authority to take to make an application for care order, or to make some application under Part 4. But there's the other question, which is after all central to this case, is did they have to? And in the particular circumstances, whatever one might say about whether benefit of hindsight in the circumstances, we're not necessarily accepting that it might have been a good idea for them to do that, and we're not accepting it. But if, for the sake of argument, that were the position, that doesn't wipe out the duty, and implicit in the duty, of course, inherent in the duty is the power, the duty under subsection 1 of section 20, because all the conditions for the existence of the duty, and we do emphasise duty and not just power, all the conditions for the exercise of the duty under section 20 subsection 1 were satisfied. And if we leave aside section 8 for the moment, because that comes afterwards, that comes after the local authority has at least taken the first step in performing that duty of providing the accommodation. Up to that point, the local authority can't be, we say, can't be said to have been acting unlawfully, because all the conditions of subsection 1 were satisfied. There was no right to make a valid objection under subsection 7, and subsection 8 was going to come along later, and I'll deal with that. Subsection 8 is another matter, but at that point, the duty applied, and they had to do that. It's not, being a duty, obviously it follows, it's just almost tautology. They didn't have any choice then. So not just it would have, not just that it's not unlawful for the local authority to have accommodated these children in this way, it would have been unlawful for them not to, because they were under a duty.
You've told us a number of times that you're going to come to subsection 8. Forgive me for my lack of familiarity with the procedures here, but I want you to imagine an example, somewhat removed from the facts of this case, where the local authority perfectly validly performs its duty under subsection 1 and takes children into, puts children into accommodation.
Yes.
And the parents may not object under subsection 7 because they're not able to provide accommodation. But a week after the children are taken into accommodation, the parents announce to the local authority, we're now going to exercise our rights under subsection 8, and tomorrow at 10 o'clock we're going to fetch up at the accommodation to which you've removed our children, and we're going to take them away. What does the local authority do in those circumstances?
Well, you can get, because your Lordship's right, you can get an obvious standoff. You can, in the terms of the statute, you can certainly get this. You can certainly get this position. You can get parents who have no ability to provide accommodation for a child, but then they exercise their unqualified right under subsection 8 by, let me take the illustration I gave a moment ago. They go and meet the child after school, but they can't provide accommodation.
Yes, but what does the local authority do? That's what I'm genuinely interested in, because I don't know what the answer is.
No, in those circumstances, my lord, in those circumstances, the local authority would clearly take urgent action under Part 4. There's no practical other answer to that. They'd have to say, okay, we have to abandon section 20 now as the appropriate way of dealing with this situation, because we have, one can take again, a slightly more unrealistic, well, sorry, your Lordship's example wasn't unrealistic at all, but take a rather more far-fetched illustration.
Well, don't worry about characterising it as unrealistic. I'm sanguine about that description.
No, I'm not, my Lord.
Not in the least unrealistic.
No, I don't know.
It would have been much more helpful if Parliament in subsection 8 had qualified the right of removal by saying on at least 48 hours' notice.
Well, as previously, of course, under the previous legislation, 28 days' notice, I think.
I'm not suggesting that, but...
No, of course not, of course not. Well, that was not a good idea, was it?
Some leeway for the local authority to get its act together and go to court for a restraining order. Well, would have been better.
Well, your Lordship is absolutely right, but perhaps unhappily your Lordship didn't have the opportunity of drafting the statute, and it might be better if you had. But it's these issues but again, we are where we are with this statute. But to give a perhaps rather more fanciful example, but it does work legally. You could have a single parent, because let's not complicate the issue with two parents. You could have a single parent who was in prison, but they got parental responsibility. Section 20, the child has been accommodated under Section 20. The prisoner has got parental responsibility, which can be delegated, and the prisoner gets a friend on his or her behalf to go and meet the child after school. But
Granny, probably.
it probably would be.
But let's be realistic.
Absolutely. I accept that realistic identification of the person who's likely to go and pick up the child. But we're assuming that Granny can't provide accommodation, because otherwise there wouldn't be the issue in the first place. So accommodation cannot be provided, and so in those few hours, something's got to be done. And again, it's the same response really as to Lord Carr's observation. Obviously, the local authority is not going to say Section 20, Judy. They're going to go
and get an emergency protection
of course.
order.
That's what they would.
That's what they're going to do.
They will do. Yeah. But in this case, once we've got, and our analysis, we say leads compellingly to the conclusion that the taking of the children into accommodation, well, initially, of course, it was perfectly lawful because it was a police protection order and so on. But the parents had no right to object. And the important thing, and as we said we'd analyse the different concepts, the notion that a person who does not have a right to object under Section 27, subsection 7, is a person whose consent is nevertheless required, is actually pretty far-fetched, because what would Parliament be doing then if it in subsection 7 said we are creating two categories here, and that is what it's doing, two categories: those with parental responsibility who do have a right to object under subsection 7, and those with parental responsibility who nevertheless do not have the right to object under subsection 7, those being the ones who are not willing and able, and so on. It would be a pretty far-fetched interpretation of the section and intention of Parliament to say, well, all right, we got those two categories, but actually consent of all of them is required. Consent of people in both categories is required. Because to say you're in the category that can't object under section 7, subsection 7, but local authority can't carry out this duty under subsection 1, or isn't under a duty in subsection 1, without your consent. That would make subsection 7 completely odious. There would have been, and Lord Wilson has made some observations. We will look at the bill, and we think we do know, if you like, what the change and what the difficulty is that emerges here. But with the utmost respect to Mr. Justice Headley and the President, Sir James Munby, those cases did not analyse, and they weren't being asked to analyse, those cases did not analyse subsection 7. They did not consider that.
But, Mr. Stewart, I think we're all rather frustrated that we never seem to get to subsection 8. Your case, can I just make sure I understand your case? Because it's quite simple. You say the section means what it says.
Yes,
object means what it says. In this case, they didn't object. Yeah. They signed a document, and you can argue about the document. It certainly wasn't an objection. So you get over the 7 to the taking. Then the question is, well, what happens under subsection 8? And they had the power to withdraw, and if they had turned up and said, give me the children, the authority would have had to do something about it. But they didn't do that. They much more responsibly and sensibly wrote the letter to their solicitors, which you have on page 2973, where they say, we give you notice of our intention to withdraw. I think they said at the end of 10 days, but we obviously want to cooperate. And that's what happened. And then the period of cooperation took rather longer than one would have hoped. But there was never a stage where you got to the point where the solicitors were saying, well, sorry, time's up now, we want the children back. And so really we never get into subsection 8 territory. I mean, isn't that what your case is? Or have I misunderstood it?
No, your Lordship hasn't misunderstood it, but I appreciate it. I'm dangling subsection 8 there and I'm promising to deal with it, but I do have quite a bit more time left to get to it.
I don't know, but
your Lordship's enthusiasm to get into subsection...
No, I think we all think it's hopeless to look at subsection 7 without looking at subsection 8. And when you've got all 5 members of the court telling you that, I would hope that you would take the hint.
No, I am listening. I am listening, my Lord, and I am sensitive. But this case has primarily been run, and what I have to deal with as well, this case has primarily been run on the basis that the consent of Mr. and Mrs. Williams was required. So having analysed subsection...
No, that was a position the judge took, because that was a position on the authorities.
Yes, but
the advantage in this court...
No, it doesn't... We don't have to criticise the judge for following the clear guidance that was given by authoritative previous judgments. We only have to criticise the judge in effect in the way the Court of Appeal did by saying it's wrong, so which is a different thing, and we do say that. But the case is run, after all, very heavily against us on the basis that consent was required. And what we're saying is that actually, and it is important, my Lord, that we say the statute means what it says, which is, of course, that we know that's not always true. But in this particular case, we say not just that it means what it says, but actually you can't escape it meaning what it says, because it is really very clear. Because and then we lead on to the question of consent, which we must get rid of because it's central to the case against us. That case after case that is referred to in case after case in the bundle of authorities proceeds, if you like, on the assumption that consent is required. And the analysis which we're now engaged in of subsection 7, we don't see a single case where that analysis has been conducted and where the point has been made that if consent is required, and we do say it is in our written case, it's not just that section 7 is otiose, but consent actually cuts against what section 7 is saying, because the very category, those not willing and able, the very category which has been disqualified from making a valid objection under subsection 7 is nevertheless given the right to block the exercise of the section 20 subsection 1 duty by simply saying I don't consent. So what we're saying is there is no room to write into this section a requirement for consent. And although the Coventry guidance in case after case after case has made that assumption, some of them, we see quite a few where the local authority wasn't even arguing and where sometimes there's a consent order and so on, but there's no case where it's actually been analysed. And the analysis that we have put forward to your lordships, your ladyships and your lordships, we say is absolutely compelling. There is no escape from that. And then if we then move on to subsection 8 from that, because we've eliminated the problems we say in relation to objection and in relation to consent, and then we are left with subsection 8. And the Court of Appeal's approach to that, we say is entirely correct, actually very simple. We're just noting, by the way, that when the trial judge, after all, indicated that the bail condition was at least a practical impediment, well, we'd say it's rather more than that, as the Court of Appeal decided, that it was a lawful impediment. And what we'd say about subsection 8, leaving aside the factual questions of when and exactly how the parents asked for the children to be returned. But as far as subsection 8 is concerned, one qualification which is, we'd say, absolutely inherent in that is the request has got to be lawful. That you must, if you are making a request to remove your child under, or well, in fact, it's not even expressed in terms of request, is it? It's actually expressed in terms of a person may at any time remove the child, but we're trusting that the situation where the child is physically removed in some sort of bust-up. We're not talking about that. So, but the removal or the clear indication that I'm hereby removing my child, that it's got to be lawful.
Now, that's a big point that I'm afraid I had not understood when reading your case. You are adding the word lawfully remove.
Well,
What do you mean by lawful?
I'm adding the word...
Person
sorry.
with parental responsibility who has all the powers of a parent.
As we explain, whether we don't use the word lawfully, we go on to explain that. The parents could not remove the children here without being in breach of the bail condition. And we say that is, and that was clearly the Court of Appeal's view, that is plainly unlawful. It's not a criminal offence, but it is the condition on which you are allowed at liberty. And for the way the Court of Appeal put it, we say it entirely correctly, is that a local authority cannot take an action which would be the result. If the local authority then were responding to a Section 8 request in these circumstances, or Section 8 removed by saying, right, all right, you're removing these children, here they are, immediately, given the terms of the bail condition, that's immediately a breach of the bail condition. And we say, quite simply, it must be unlawful.
What's the consequence of breach of a bail condition?
The consequence...
We asked that quite some time ago.
Yes, they did.
We asked Miss Fottrell, we didn't ask you, so I'm asking you now.
No, indeed. I'm on my feet and I have to answer the questions. The consequences, we understand it, is that it's not a criminal offence, but you are subject to being arrested. You are arrested, you can be arrested. You can be lawfully arrested for breach of a bail condition. And then, of course, the immediate possibility, it's not an absolute certainty, of course, but a very likely result is that your bail is revoked.
It would be helpful to have chapter and verse.
We'll get some chapter and verse overnight for your ladyships and your lordships on this, but that's our
I mean, my understanding is that you can be arrested if you fail to turn up in breach of your bail conditions.
You certainly can that, my lady, but
It's the other bit that I'm wanting chapter and verse for.
Can you remind me where the Court of Appeal deal with?
I beg pardon?
Where do the Court of Appeal deal with 28?
But Mr. Sinai says that there is helpful guidance in the trial judge's judgment in relation to the question of bail. Can I say that our understanding of here we are, Section 67. I think we referred to it before, my lord, but Section 60, paragraph 67 of the Court of Appeal's judgment.
I think it's paragraph 60, the final sentence. Breach of a bail condition entitles the police to rearrest the bailed person, but such a breach doesn't constitute a statutory offence.
Sorry, my lord, we've got two paragraphs here. One in the judge's judgment.
Yeah, then
Page 2942, under the heading police bail.
yeah,
Paragraph?
Yeah, paragraph 60, my lord.
that's the one I'm referring you to.
2942.
Yeah.
Yes, that's the one I'm referring you to.
Yes, indeed, yeah. That's section. Bail in this case was granted under the powers accorded to police by Section 37 of the PACE. Conditions may be imposed by Section 47. The person bailed has a right to apply to a magistrate's court for a variation of the condition, which I think we discussed earlier today. The condition can be varied by the breach of a bail condition entitles the police to rearrest the bail person.
Well, yes, it says that, but I've been looking at the Act, and I haven't found it yet.
Section 46 of...
Well, that may be it, that may be it. As I said, I haven't found it yet.
46. I have got that. I don't necessarily say I've got lots of copies at the moment, my lady, but this is pace...
Well, tomorrow morning will do.
Oh, will it, my lady?
Yes, definitely. Yes.
Yes, all right. Well, that's...
And you can refer me to where the Court of Appeal deals with Section 28.
Section 28. First of all, my Lord, can I say the reason for the continued, yes, at 76, the continued existence of the bail condition had the twin consequences, and we referred to this earlier. Firstly, they were prevented from providing a suitable accommodation. Sorry, but secondly, we're not. Beg your pardon. Secondly, we're not able to.
Lord Carnworth wants
Sorry,
to answer to his question.
Yes,
where does the Court of Appeal deal with Section 28?
Yes, we're just trying to find that. Paragraph 36 at 2893.
Thank you.
That's where we pick it up. Under Section 28, anyone with parental responsibility, no requirement, power of immediate refusal. Thus, the local authority cannot prevent the parental right, even if the right's appropriately exercised. But then, well, that's not dealing with...
Yes, I've seen that.
Yes, it's not... It's not...
Deal with
It's... Sorry?
this case. Or maybe again tomorrow morning.
Yeah, I think... It's at 75, that's what page it is. At 2909, on any showing, it was not for the local authority to aid and abet the flouting of the bail condition, and it is not sufficient to argue that the local authority should have sought to persuade the police to modify the condition. The only inference to be drawn from the fact the condition remained in place was that the parents, no doubt on advice, were prepared to negotiate with the police rather than risk a conflict in court. In those circumstances, that's to do with whether they could provide accommodation. But the Court of Appeal is saying especially it's not for the local authority to aid and abet the flouting of the bail condition.
But I mean, I couldn't find a reference to Section 28 in terms. The best I could do was 75, as you say, where he seems to be saying, well, in fact, the parents, because they felt they had to negotiate, never took it to the point of actually exercising their power to withdraw. But the way on how's the negotiations being conducted through the solicitors. I thought that was your case, but I...
Well, no, that's our case as well, my lord. We do say that that there
but
was...
Is the answer the Court of Appeal doesn't deal in terms with Section 20, subsection 8?
It doesn't say it. It doesn't say it. It doesn't say it explicitly, my lord. Sorry, that's why I was struggling really to find it, because it doesn't say it explicitly, but we'd say that it is very plain from what they've said there in Section 75. It's not for the local authority to aid and abet in the flouting of the bail conditions, and we would say exactly that the position is, as the trial judge helpfully summarised, the position under we will get the chapter and verse on it, but as far as bail is concerned, it's a condition of you being at liberty. You are liable to be rearrested, and of course the reaction then will be maybe to rescind your bail or to impose different or more stringent conditions. That would be the effect. But we do say that that to ask under subsection 8 that to ask for your children to be removed when you will immediately be in breach of bail conditions is not a valid exercise of that right under subsection 8.
Well, you might as well leave that thought
Dangling.
dangling. And we shall look forward to hearing from you further at 10:30 tomorrow morning.
With some authority to support the submission.
Thank you.